This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hivner. On behalf of the judges McBrayer and Armstrong, welcome to our attempt to keep the courts open and visible by having these hearings on Zoom. I assume there are no questions and everything's worked out. So, Mr. Hivner, would you call the case, please?
Christina Lynn McCartney versus Lester Dale McCartney et al.
Okay. Is the appellant ready?
Yes, Your Honor.
All right. You may begin when ready.
Yes, Your Honor. My name is Adam Holland. I represent the appellant, Mr. Lester Dale McCartney. I also represent Mr. Ronald McCartney, who is a party with a limited capacity in this action. Essentially, this is a divorce case, Your Honors. The parties were married for 14 years. The appellee is Mrs. Christina McCartney, and this was a 14-year marriage. There were no children born of this marriage. When the parties met in late 1999, both of them had accumulated significant assets. With Miss Christina McCartney owned property, I believe on Flat Top Mountain, if memory serves, and Mr. Dale McCartney, Dr. Dale McCartney, he is a physician, owned property in Sequatchie County in Sequatchie Valley. Now, at the time of the parties' marriage, Miss Christina McCartney, this was her third marriage, and it was my client's first marriage. And the parties engaged in extensive discussions about how they were going to manage their affairs, because certainly both of them were established professionals, again, with my client being a medical doctor, and with Miss Christina McCartney at the time, she was a pharmacist, a licensed pharmacist. And so they had extensive discussions about how they desired to keep their financial accounts separate, how they desired to maintain their own separate property. Again, they had discussions, and this was all in the trial record, about how they desired to keep their investment and retirement accounts separate. But they did desire to live together as husband and wife, and to manage each affairs of the other. And that's what they did. Now, the hobbies, there was proof at trial submitted. The husband, Dr. McCartney, he was into airplanes. He was into flying aircraft, experimental, amateur aircraft. And the wife, she was into horses. And so they would work together to allow each other the space to accommodate their hobbies. But again, this was a marriage, and you don't typically see marriages like this where the parties for 14 years never jointly title any assets, where the parties never put each other on their own bank accounts. Again, there was tremendous care to maintain separate accounts and separate properties throughout this marriage. And again, this is not what we traditionally see in a marital relationship. And so the parties went along. There was some difficulties that they had in 2003. There was a brief period of separation and a subsequent reconciliation. But ultimately, the parties were ultimately filed for divorce. I believe in 2015 is when the case was filed, and the case was tried in 2020, January 2020. I was my client's, I believe, second counsel. And I came in, I believe I was on this case for about 4 months until it was tried. And so, again, a lot of these issues have been briefed. Our position in this case is that when you look at the totality of the circumstances and the intent of the parties, and again, how the parties decided to structure this marital relationship with great care, obviously being given to keep assets separate and apart, we do believe that the trial court, the evidence preponderates against certain findings and factual findings of the trial court with regards to how some of this property was classified. One of the biggest issues being the retirement accounts. As the proof showed at trial, Dr. McCartney had a significant, he'd worked for about 15 years as a physician. And at the time of marriage in the year 2000, he had approximately $187,000 of memory serves and retirement assets. He continued to sporadically contribute to those accounts after the marriage, but his contributions were not significant. The proof showed at trial that most of those gains were driven by market forces. The proof showed at trial that Miss Christina McCartney maintained her own retirement accounts and kept those separate. And again, going back to how the parties decided to structure their affairs, great care, again, was to keep these accounts separate and apart. And that's what Miss Christina McCartney did. And so at trial, the court found that Miss Christina McCartney had an interest in all of the funds accumulated after the date of the marriage in the retirement account. And we contend that the record preponderates against this because the proof showed at trial that a vast majority of the increases in Dr. McCartney's retirement after the date of the marriage was driven by market forces, and that we do believe that this presumption, this rebuttable presumption that any accumulations in retirement accounts that occur after a marriage, we believe that it was rebutted and the burden shifted back over to the wife, the spouse, to articulate what monies in that retirement were indeed marital. I mean, because we certainly believe that the record established in this case that, again, the vast majority of those increases in Dr. McCartney's retirement were attributable to market forces.
Let me ask you, Mr. Holland, where
Yes,
in the record do I find this proof where you assisted the court in trying to make a determination about what amount of the appreciation was solely due to the premarital balance? What volume, what page, where do I find that?
I don't have a specific site. That would be in the testimony of Dr. McCartney when he's asked about the retirements. I believe this was cited in the brief, if I recall, but he did testify, and the court ultimately found that Dr. McCartney had not made significant contributions during the marriage. I believe it was after 2006, because what we had happened in this case, and the court found that Dr. McCartney had an accident. He was in a plane crash, I believe, in 2006. And then approximately a year later, he suffered a tumor, a pituitary tumor, and then he was out on disability and had extensive difficulties going back to work. And it was around this time that Mrs. McCartney lost her job because of theft of narcotics from her employer. And so she suffered an interruption in income. Now, in this case, the court equated Dr. McCartney's accident with Mrs. McCartney's substance abuse issues. Now, we certainly respectfully disagree with the trial court on that point. We believe that an accident,
let me make sure I understand what you're arguing, because you've said that he didn't make any contributions to the retirement account after the marriage. As I understood from looking at the briefs and also the order, that during the marriage, he contributed in excess of $100,000 to the retirement account, maybe as much as $180,000, and that the value at the time of the marriage was the 187, which obviously is a separate property, and any appreciation in that would be his separate property. And that's why I asked you earlier, what proof did you put on to assist the court in trying to make a determination about the appreciation that relates solely to the premarital balance? And I don't know if I understood your answer about what that proof was.
The proof was in the form of, it was Dr. McCartney's testimony on the point that there were many years. There's not a specific value figure on that. Dr. McCartney had difficulties with that point. His testimony ultimately was that there were many years that he did not contribute into those accounts. And the court found that that was the case. And it's our contention that that proof is sufficient to show that the vast majority of these gains in this retirement account were attributable to market forces.
So
Now,
are you telling us today that after the marriage, he didn't contribute anything to that account where he had the 187 balance?
no, that's not correct, Your Honor. Dr. McCartney did contribute sporadically, but that there were the bulk of the marriage he did not contribute. There were a few years where he did.
Well, can we talk about the amount rather than the bulk of the marriage? What was the amount contributed?
Your Honor, I do not know what that amount was. That proof, if memory serves, was not articulated at trial. It was no one could determine that. And so that's where we are on that issue. And I see my time is close to being expired. If there are no further questions, I can address some of the other points of this on rebuttal.
Seeing no other questions, Mr. Bloom.
Good afternoon, Your Honors. So very nice to see you, and we got to stop meeting this way.
Eventually we will.
Eventually. This is kind of nice. I don't mind it at all. I represent Ms. McCartney, the appellee, and I was ready. I don't want to get totally sidetracked. I was going to jump in with Judge Armstrong's question, but I think Judge, you've got a pretty good grasp of what's going on. I mean, I think I covered most things in my brief with citations to the record. In point of fact, Judge Armstrong, you are correct that $187,000 of marital income was contributed into these 5 different retirement accounts at the time of, and I also want to make a slight correction. I'm going to put in a motion on page 14 of my brief. I basically said between 2008 and 2014, the husband contributed $182,493 into his, I think I said, into his Fidelity account, which was his separate account prior to marriage. In point of fact, it was contributed into all 5 of his retirement accounts. Now, what is uncertain and what Mr. McCartney did not establish is how much was contributed into each of these accounts. We don't know that. I do know that, for example, with a Fidelity account, which was his separate property, his at least the premarital value of $187,000, I think it was. At the time of divorce, it was $213,000. So that had only appreciated by $30,000. And I also just want to dispute the idea of the bulk of the retirement value is based upon the market appreciation. I mean, in point of fact, if you look at, if he had $187,000 in it, contributed $182,000 during the marriage, that's a little less than $400,000. At the time of divorce, the total value was just under $500,000. So that's, if you want to call that, the bulk, certainly the bulk of this, of the marital portion of it is not from market forces. It's basically $182,000 of it was contribution. So with that said, basically this could have been, as the judge said, a very simple case if only there'd been a prenuptial agreement. And of course, the party certainly knew that something was amiss even in 2004 when they separated for a while. Certainly when Mrs. McCartney had some drug issues, they knew that there could be some issues going on. They never chose to do a prenup. The husband's position is that basically there was an oral prenup or some sort of gift of financial independence to each other, a term which I've not heard of. The wife's position was basically she agrees they kept their accounts, their bank accounts separate. They probably put their income into their separate accounts, credit cards separate. They paid probably their own credit card bills and whatnot. But they were going to contribute equally to the basic household expenses. There's no, and even that was just roughly equal. There's no sort of idea. There definitely were not any quote extensive discussions, as Mr. Holland mentioned, about the retirement accounts. In fact, when the husband was asked about it, his question was, I assumed it was. That's what he said. And as far as extensive discussions otherwise, that's solely the husband's testimony, which is disputed by the wife. According to the wife, both were professional people, significant incomes. They had expensive hobbies, and both did agree the reason they did this, they just didn't want to fight about how they were spending their money. They had plenty of money. They had expensive hobbies. They didn't want to, cause finances to be a marital problem. So in the absence of a prenup, all the trial court could do is listen to the evidence, look at the exhibits. And again, the exhibits, there was a big problem of all these paybacks that Mr. McCartney is trying to credit himself with to try to retroactively show that he paid Ms. McCartney back for everything or whatever. Strangely enough, there's no documentation of it. It's just his testimony. There's no checks, there's none of that. So the trial judge for saying in the absence of a prenup, all he could do is, look at the evidence, the exhibits and whatnot, and determine whether the evidence was sufficient to overcome the clear language and intent of TCA 36-4-121. Now, there was some agreement between the parties. They did keep things separate, their income and their credit cards and whatnot. They roughly, and this is the husband's testimony, they roughly kind of tried to equal out the household goods. And he said there was like a lot of latitude in it. They weren't going to get obsessive about it. It wasn't anything which was on the straight and narrow. It was not that way. Now, the disagreement comes with the husband basically saying everything was separate, which actually would leave the wife walking away with after a 19-year marriage. Granted, they separated the last four years, I guess, essentially walking away with nothing. So the questions with the trial court was basically, is there sufficient evidence here to show an intent to have what would be an oral prenup agreement? Here are the testimony, and he agreed with the wife. The judge himself found as a fact, the parties were acting as a team. It was the income was marital. They chose to purchase the funds, which purchased things with the funds that they had, and they enjoyed a lifestyle based upon their joint efforts. This was a marital partnership. Now, all of these things, but we're dealing with the standard. I think the standard of review should carry this through. Does the evidence preponderate with convincing effect against the trial court's conclusions? I'd say pretty resoundingly it does not. The conduct of the parties. Now, again, the husband provided very little objective evidence to support his position. Most of his brief actually is his testimony. With my brief, I did try to balance it out. Of course, we know who I'm fighting for, but I tried to be fair in that regard. There was no mutual verbal contract as urged by there's nothing formal like that. It was basically two people living together. They earned decent incomes. They didn't want to get in other finances. One of the main causes for divorce and strife. They just wanted to let things go. Now, a lot of the evidence shows that basically it was a partnership. Again, I put the litany of this in the brief, but the wife paid off the marital home. She contributed funds to furnish, electrical, curtains, things like that for the marital home. She contributed funds for the addition of the marital home, a garage and another bedroom. I think it was. She paid for a tin roof for the barn. She bought equipment for the barn, and most of this was documented. It's not just her testimony. I think, I'm just saying that. I think that's correct. She had a lot of documentation. She put a down payment on the John Deere tractor. She paid more than her share of the income taxes. She was a W-2 employee. He was a 1099. Now, the husband says he paid her back for all these things. There's no documentation. In fact, he says he went back between 2000 and 2013. He found $53,000 that he paid for her benefit or directly to her. That's just his testimony. There's no documents of that. Now, the wife was a primary driver of his vehicle. He paid for her insurance. The husband paid money for her, helped her with the horses financially. Again, no amounts are stated. Actually, in order to try to equalize things or to show paybacks, he had to say, well, I'm also valuing my in-kind labor. Now, the wife also did in-kind labor with the barn and whatnot. Now, on the retirement accounts, again, I got 6 minutes left, good. On the retirement accounts, again, he had 5 different retirement accounts. One of them was One of them was this Fidelity account, which was definitely his separate property to begin with. I think he also had a Mutual of Omaha account of some small amount, which would be his separate property. And as I mentioned, he contributed $182,862 into those accounts from his income during the marriage. I've already mentioned that I'm going to correct that page 14, where I kind of indicated that if you just read that, later on I say it correctly, but if you just read page 14, it looked like you put $182,000 into his, what would have been his separate account, but for his contribution of marital funds into it. Now, in that case, I don't think substantial contribution is really an issue. You know, commingling is more of an issue. Now, I shouldn't do this, but if anyone had, I shouldn't do this, but to be fair, if there is any error whatsoever on the trial court's decision, it would be on basically not doing some sort of apportionment on that one account about saying, okay, it was started out with this amount of money. He put in, well, you'd have to find out how much he put in and do a percentage for the appreciation. However, whose responsibility is that to do? Does the judge supposed to just try to come up with that on his own? It wasn't even suggested that he do that, mainly because Mr. McCartney's idea from the get-go was this is all separate property. Classification is not an issue. I mean, that was one of the problems.
Let me ask you, Mr. Bloom, in looking at the record, will we be able to determine what was the premarital value of each account?
Yes,
I know we have the one, but what about the other four?
Oh, the other four were started during the marriage.
Started during the marriage. Okay.
Right. So yeah, exactly.
Right.
And the total value at the end was $487,966. And I'm not always good with my math. I'm also going to correct pages 30 and 31, or just a figure that I'm going to correct. On page 30, I'm going to basically, it said that the husband's fidelity, it's the second full paragraph, husband's Fidelity IRA account, which was a separate property, which had a premarital value of $187,862, grew to, and I think I put in that $487,000 figure. That's wrong. In fact, it grew to $213,982, as I suggested at the beginning. And then, you know, that was, and the other thing which I needed to correct at the bottom of page 30, it says with the deduction of the $187,862, which was his premarital value of the Fidelity, the value of a husband's 5 marital retirement accounts funded with the marital income, all of which funded with the marital income, was, and I put that $487,000 figure, that's wrong because I have to subtract the 187, you know, the premarital value. It should be, was $300,000, $300,108. I will correct that. And I'll also correct that one line on my Rule 7 table. So, I mean, with that said, evidence was just, I mean, it just was not sufficient to support some sort of oral prenup agreement. I mean, the party's conduct, the wife testified to the contrary. Now, the judge didn't make a credibility decision, you know, express, but he certainly agreed with the wife. And as Judge Armstrong, you know, I'm going to infer this, it's not fair. It might not be fair, but I'm going to infer this. There's just the proof, the documentary type proof that would otherwise be available to Mr. McCartney just isn't there. And for him, you know, it's really kind of retroactively trying to solve things. As far as the distribution is concerned, I went through all of the factors. The parties are relatively equal. Matter of fact, Mr. McCartney is probably in better shape than Miss McCartney is with his, you know, he's basically satisfying his needs. He's still got, you know, a lot of the he's not having to go into retirement accounts for living expenses. I believe that lastly, what could, the other thing which I was worried about to begin with, you know, I mentioned the thing about the appreciation of the Fidelity account, and maybe you should do some sort of percentage wise. And again, whose responsibility it is based on the record, what could the judge do? All right. The other thing would be this the lost wages income. I think it's pretty clear. Now, I think the judge did kind of divide that between lost wages during the marriage and future lost wages. I believe that what he awarded, and is only 35% of that, is the lost wages during the marriage. And I think that is, by definition, marital property. So at any rate, I hope I haven't totally confused you. I kind of rely on my brief, but do you have a question, Judge Armstrong?
All right, the Fidelity account that went from 187 to 213, were the contributions made to that account during the marriage?
I assume that they were. Again, there's a lack of proof. We know that the gross amount that was contributed to all of the retirement accounts, but we do not know. I think there's an exhibit 99 perhaps, which might be helpful. I couldn't determine that. I think if I could have found that, I would have put that in. I think it's an unknown about where that 180, it's either 182 or 187,000 of marital funds contributed. I'm not sure. I think it's unknown which accounts they went into.
Okay.
There are 108 exhibits, so 99 might be helpful.
Thank you. Thank you very much. Mr. Holland, you have your rebuttal time.
Yes, Your Honor. And so this, and I'm ready to proceed on rebuttal.
Go ahead.
Thank you, Your Honor. First off, their wife had serious credibility issues. In this case, obviously, there was substantial proof received, unrefuted proof that wife had lost her job as a pharmacist. Her pharmacy license was suspended. She had to go through a rehabilitation program. And again, ultimately, it's not just that wife had a pill addiction. Wife also was stealing from her employer. And wife testified that she would take some of husband's cash money that he would receive from baling hay without husband's knowledge. There was proof in the record of that. There was this issue of a fraudulent conveyance that wife attempted to litigate, where she claimed in an amended pleading that she recently found out about the fact that Dr. McCartney had conveyed or transferred the farm property over to his father, when in fact wife had known about it for years, and wife had come back and had an opportunity to correct her amended pleading, and she didn't, and then she did. Wife had misrepresented with regards to how much money she was making, claiming, I believe, she was making between $45,000 and $50,000, when in fact she made in excess of $72,000 a year leading up to trial. There was much testimony received from wife on cross-examination that showed that she was not truthful about several different points. Much resources were spent on litigating this fraudulent conveyance issue, when ultimately it was not a meritorious issue. That this was not a real issue. Obviously, the real issue dealt with what was marital and what was separate, in light of how the parties chose to conduct their marriage, how the parties chose to take great care to keep their assets and their bank accounts separate and apart. That when you look at the record in this case, ultimately there was not much in the way of marital property here to divide, again, where the parties took great care to keep their finances and their assets separate and apart. And you can even look at wife's own conduct. She cashed in her own 401k prior to this case being tried. Now, the court took that into consideration and made that finding. But it goes back to wife's understanding, the party's understanding, that their retirement accounts were to remain separate. And then just to address these disability payments that husband was receiving, husband is disabled. These parties are not on the same footing. I believe the record clearly preponderates against that finding. Husband was at 61 years of age at the time of trial. I believe wife was 55 years of age at the time of trial. Wife is healthy, able-bodied, and continues to work as a pharmacist. She was able to regain her pharmacy license, and she continues, my understanding to this day, to practice as a pharmacist in the state of Alabama. And so this suggestion that they're on the same footing is not correct. And we briefed this issue. We do not believe that the facts of this case support a 50-50 division of this marital estate. We do believe that wife is in a better position to work and to earn than husband is, where husband is on disability. And we do believe that the disability payments a husband have received, they're not for, they're for lost income, in that they should have remained his separate property. They were not commingled. They were kept in a separate, I believe, a first volunteer account. And there's exhibits in the record reflecting what those values were. But we do not believe that husband's, again, disability payments that he received prior to trial were marital property, where those payments were to replace lost income. We do not believe that the record supports a 50-50 division of this estate. And again, and that goes back to the equities in this case. What's equitable when you look at the relative position of the parties. When you look at wife's own bad conduct, this bad faith, this concept of bad faith, that not only, occurred during the marriage with her substance abuse issue, but carried over into the trial of this case, where she's misrepresenting facts and pleadings and verified pleadings that she files with the court, and being deceptive about what her income really is, things like that. Litigating a frivolous issue that took up resources. Respectfully, Your Honor, we do believe, and we'll stand by our brief on these various issues, that certain facts in this case preponderate against the trial court's rulings. And we'd ask for the relief requested in our brief. Thank you, Your Honor.
Thank you, Mr. Holland. Thank you, Mr. Bloom. Mr. Hivner, would you recess court?
This honorable court is now adjourned.
Okay. Court is